Welcome. My name is Rawia Ayache. Today's session, contract administration, is about what actually prevents construction disputes in practice. Contract administration isn't paperwork for its own sake. It's how risk is actively managed throughout the life of the project. Most disputes that we see aren't caused by bad contracts, but by poor administration of perfectly good ones. So the role of contract administration in construction, it ensures project success, key functions, and well-administered contracts create clarity, certainty, and evidence. Poor administration leads to missed deadlines, payment disputes, invalid claims, and ultimately litigation. This seminar is about identifying those pressure points early. Okay, so just more of an intro. The definition of contract administration, the process of managing, monitoring, and ensuring compliance with all terms of a contract throughout its life cycle. Its importance, proper contract administration minimises risks, prevents disputes, and ensures projects run on time and within budget. Now, to give you an example, the Sydney Opera House, a landmark which we're all familiar with, is a classic example of administrative failure, not just design ambition. The construction of the Sydney Opera House began on 2nd of March 1959, and it took 14 years to complete, significantly exceeding the original 4-year deadline and budget of $7 million. It actually ended up costing $102 million. Now, the construction was defined by severe conflict between the architect and the New South Wales government, and it has been characterised as a grand dream turned nightmare. Contract administration is about discipline, maintaining control of the scope, the time and cost throughout the project life cycle. So, legal frameworks for contract administration. We've identified 3 standard contracts, which I'm hoping most of you are familiar with, the Australian standards. So the AS 4000s, which is the D&C. Today we're going to be using AS 2124, which is the traditional construct only for practical application of our theory. The second legal framework is the Security Payment Act, which obviously governs payment claims and the adjudication process, ensuring cash flow for a project. And 3 common law principles, things like implied terms, good faith, and reasonableness. What's important to note here is that security of payment operates alongside the contract and not instead of it. And common law principles won't rescue parties who fail to follow their own contracts. So there are 4 points of contract administration review. I want you to think of contract administration as these 4 checkpoint reviews, and that is the contract signing, the monthly reviews, practical completion, and final completion. If something is missed early, it compounds later and often irreversibly. So, importantly, with contract signing, ensure all preconditions are met before the work starts. With monthly review, track things like progress claims, compliance and risk assessment. In practical completion, look at the project handover requirements stipulated in the contract. And in terms of final completion, make sure that you're closing out financial and legal obligations in accordance with its terms. All right, we're going to jump into the first component, which is contract signing. The contract signing checklist. The biggest mistakes are made before a shovel hits the ground. This checklist is about locking down certainty before the work starts. So why is an initial checklist critical to avoid disputes? Once the contract is executed, your ability to fix drafting and risk allocation is extremely limited. So what it does is it helps establish clear contractual obligations for both parties and reduces the likelihood of litigation. Now, the checklist overview for contract signing, we think, should confirm key contractual clauses are properly reviewed, ensures statutory and regulatory requirements are met, identifies any ambiguities or missing provisions that need to be addressed before the execution, and aligns parties on contract interpretation and administration expectations. So licensing and insurance and approvals are not administrative formalities. Non-compliance here can invalidate claims later or expose parties to uninsured risk. Key contract signing checks. These are your future dispute hotspots. So things like scope, time, payment, risk, and notices. If these aspects are not clearly addressed now, they'll be litigated later. So just looking at the 7, scope of works, it's important to ask, is the deliverable clearly defined? Are timeframes, completion dates, and liquidated damages accounted for? The dispute resolution mechanisms, are mediation, arbitration, or expert determinations clear? And our notification of deadlines clearly outlined for variations and EOT claims. So, scope of work. There's some references in the top right-hand corner referencing particularly the provisions of AS 2124. I encourage you to read those as we're going through each of the slides. It identifies the clause as well as the clause title and just a short description. I might not take you through all of that. I might focus on the key checks and the common issues. But in terms of the scope of work defining deliverables, scope is the clarity that you need. It's the foundation of payment entitlement. If it's not in the scope, you're likely to be arguing about variations or claims on a quantum merit basis, both of which are costly and uncertain. So what we commonly find is that scope gaps lead to these variation disputes. If there's a lack of clarity in specifications and performance requirements, and if undefined interfaces between subcontractors and head contractors give rise to significant escalation. The program milestones. Are contractually agreed project start and completion dates documented? Are extension of time provisions clearly outlined? These are the questions that you should be asking in ascertaining whether the construction program and the milestones stipulated in the contract are sufficient to meet the necessary objectives. What we find is unrealistic programs create sort of automatic liquidated damages exposure. It's really important that liquidated damages are reasonable and tied to real loss, and extension of time mechanisms actually work. So it's worthwhile that you pay close attention to those. Risk allocation. This has been an important one in recent time, particularly with the force majeure provisions. It's important to ask, has the force majeure provision been properly defined? That has become significant since COVID-19. We think that risk should sit with the party best placed to manage it. Broad indemnities and unclear force majeure clauses are the most common source of dispute. Are liability caps reasonable, and do they exclude consequential loss? Some of these undefined liability limits lead to some financial exposure, unduly. Okay, payment terms. It's important to check that progress claims have been structured correctly in accordance with the contract, as well as payment schedules, whether they're realistic and aligned with cash flow expectations. It's not uncommon for principals to write in provisions with respect to payment schedules that impact a head contractor's cash flow. And so it's important to get those right. And so what we say is sort of cash flow disputes derail projects quickly, and progress claims must comply with stricter contractual requirements or they risk rejection and delay. Insurance and security. You've got to check. Have all necessary insurances been arranged and verified? Are subcontractors providing their own insurances, and is the principal adequately insured for the project risks? So insurance transfers risk only if it's current and adequate. Expired policies and misaligned security are reoccurring litigation failures. So it's important to keep track not only prior to entering into the contract, but during the progression of the works, that all insurances kept up to date. Number 6, dispute resolution mechanisms. It's important to ask in the contract, are the dispute resolution steps clearly outlined, and whether or not the contract specifies when mediation versus arbitration applies, and is there an expert determination process for technical disputes? So dispute resolution provisions are not boilerplate. They dictate how and how quickly conflicts escalate, particularly during live projects. Time bars and notices. Now, courts enforce time bars strictly. Missing a notice deadline often means losing the claim entirely, regardless of merit. So it's really important that you ensure notification deadlines for variations and extensions of time are clearly outlined, and that time limits are enforceable, and whether or not they provide reasonable notice periods. And if the process being defined for dispute escalation during time bars has been clarified as well. In the recent case of Mann v. Patterson, actually not so recent anymore, the High Court ruled that failure to properly define variations and scope in the contract led to disputes and quantum intermediate principles applied in the absence of clear scope documentation. So in this instance, a contractor performed work beyond what was reasonably agreed in the contract, and disputes arose over whether additional payments were due for work, and that was not explicitly included in the contract scope. So the issue then became whether the builder was entitled to additional payment for variations not properly documented. And the court said, a builder shall not be entitled to recovery in money in respect of owner-initiated variations except in accordance with these provisions. They function as protective provisions designed to prevent all kinds of problems likely to arise when a contract variations are dealt with informally. In particular, to avoid surprises and consequent disputation likely to arise when plans and specifications are varied without degree of formality mandated by, and in that instance, the provisions of the relevant domestic building legislation in Victoria. So this case reinforces that informal variations are legal and a financial trap. Without contractual compliance, entitlement is exposed to serious risk. And so it's really important to ensure that variations are properly agreed in accordance with the terms of the contract and that those provisions are met. Monthly review checklist. So once the contract is live, administration must be continuous. Monthly reviews provide sort of some clarity and prevent small issues becoming formal disputes. So why are monthly reviews essential? These reviews ensure compliance, protect entitlements, and preserve evidence. They are just as much about disputes you don't have as the ones you do and later defend. So the monthly reviews identify issues before they escalate and provide a structured approach to risk management. So just moving on to key monthly review areas. We've identified 5. Progress claims and payments, insurance and licensing compliance, time bars and notice compliance, risk management and site compliance, and subcontractor and supply chain management. These are 5 areas represent where most live project disputes originate. Number 1, check timing and contract valuation. Payment disputes usually arise because claims don't strictly comply with the contract. So it's really important to verify submission deadlines for monthly payment claims, ensure payment claims meet contractual requirements to avoid rejection. You've got to check progress payments aligned with actual work completed on site. and address any disputes over underpayments or delayed approval of claims. So moving on to insurance and licensing compliance. Compliance isn't static. Subcontractor insurance failures frequently expose head contractors, we find. And so to minimise and mitigate any risk associated with that, confirm that public liability, workers' compensation and professional indemnity are up to date. Ensure your subcontractors provide proof of active insurance before you give them site access. Ensure their licenses are valid and compliant with statutory requirements, and check if additional security or blank guarantees are still active if required. Number 3, time bars and notice compliance. So this is where entitlement is either preserved or lost. Monthly tracking of notices is essential. Key checks include ensuring all changes are properly documented and formally approved, checking whether all delays have been assessed and reported within the contractual timeframes, and confirm whether any notices need to be issued to subcontractors or suppliers regarding pending claims. The number 4, risk management and site compliance. Site records form the backbone of delay and disruption claims. If it's not documented at the time, it's really hard to prove later. And so it's important to review safety and environmental compliance, track potential project risk, document any emerging issues, and ensure a site risk register is updated progressively as the project advances. Number 5, subcontractor and supply chain management. Subcontractor disputes escalate quickly, and so managing their claims and compliance protects the head contractor's position. So what does supporting documentation look like for monthly reviews? Here are some examples. They could be progress reports that compare actual work versus the scheduled milestones, site diaries, which capture the daily events, meeting minutes to ensure all agreements and discussions between the relevant parties are documented, and financial reports that track costs, cash flow forecasts, and potential cost overruns. So these documents become evidence. Consistent, contemporaneous records carry rule weight in disputes. So just looking at AS 2124, these 4 clauses together, programming, variations, claims and payments, it's important that contract administration aligned with all of them, not just one. They all work together. So just looking at clause 33, it outlines contractors' obligations to provide updated program. Clause 35.5 specifies the timeframe for lodging delay notifications. And clause 42 sets out the procedures for submitting and assessing monthly claims. This is a case, CMA Assets versus John Holland. What this case shows is the courts enforcing notice regimes ruthlessly. CMA Assets, being a subcontractor, was delayed in works due to late access provided by John Holland. CMA gave notice of the delay 3 weeks after it first occurred, contrary to the contract. And the court had to determine whether or not CMA was entitled to an extension of time despite providing that late notice. And what the Supreme Court of Western Australia determined is that CMA's claim was rejected because they failed to meet mandatory deadlines as stipulated in the contract. And John Holland was entitled to insist on the strict contractual position and deny liability for delay. So, as I say, ruthless if not met. Just moving on to practical completion and closing out the major works. So practical completion is a legal turning point. it affects liquidated damages, security, and defects liability, all these things that sort of come to a head at the end of the project. It's important to have a checklist for practical completion because it marks the formal handover of the project. It determines when liquidated damages stop accruing and triggers the release of security or retention funds. It also starts the defects liability period and ensures contractual requirements are met. So certification and PC must be accurate and unqualified. Conditional or partial completion creates uncertainty and exposure. So here are some key practical completion review areas that I'm going to take you to. There are 9 of them, and they address issues that commonly delay certification or invalidate it. So defects liability and inspections. It's important to conduct a joint site inspection with the principal and the superintendent. Identify and list minor defects and incomplete works. Confirm a schedule for rectification of any defects, and ensure subcontractors provide final defect and rectification reports. Minor defects don't prevent practical completion, but incomplete work does. And that's why the defects liability, the defects inspection at PC is significant and important and shouldn't be overlooked. And number 2, compliance and certification requirements. So statutory compliance is non-negotiable. And without it, it's often that practical completion cannot occur. And so this would involve obtaining all, final certificates, whether it's occupation, fire safety approvals and statutory sign-offs, ensuring all statutory approvals are met before practical completion is certified, and verifying the work complies with specifications and regulations. Number 3, handover documentation. So these include sort of operation manuals, as-built drawings, warranties. It sometimes involves providing training for the use of key systems, whether it's mechanical, electrical, or fire. And also, significantly, the issuing of handover notices in writing to formalise completion. These are often contractual deliverables and not afterthoughts, so it's really important that they be identified early on to ensure the practical completion process runs smoothly. So retention and release triggers. Point 4. Security release depends on sort of proper certification. Principals often withhold security where procedural steps are unclear. So as a head contractor, it's important to ensure practical completion is formally certified, that the principal has no outstanding claims, and verify if there's any conditions that are imposed on the early release of security. Now, just moving on to some of the references in AS 2124. So Clause 37 outlines the obligations during the defects liability period. Clause 35.6 specifies when liquidated damages stop after practical completion. And Clause 42.9 covers security, retention, release conditions after completion. So these provisions ultimately control when the liquidated damages stop and when the rights shift after practical completion. So number 6, liquidated damages. It's important to assess if any delays beyond the contractual completion date apply. Ensure that all extension of time claims have been properly assessed before applying liquidated damages. Confirm that the principal has followed due process in enforcing liquidated damages, and cross-check whether contractor caused delays have been quantified. LDs commonly apply after proper extension of time assessment. So applying LDs prematurely risks breaching the contract. Point 7, extensions of time, EOT review. So extensions of time entitlement depends on the timely notice and supporting material. It's important that delay analysis is credible. So when you are going through the process, it's important that all EOT claims have been properly submitted and reviewed, that you verify extensions of time granted align with the contractual entitlements, and ensure all supporting documentation is on file, and that includes sort of correspondence and delay analysis. The final site cleanup and readiness for use. It's important to conduct a final walkthrough to check for any safety hazards or non-compliant works. Ensure waste materials and temporary works are removed from the site, and confirm that utilities, power, water, drainage are fully functional. So the project must be safe and functional and ready for use. Subcontractor closeout. Ensure that all subcontractors have completed their final works. Verify all subcontractor claims have been submitted and paid, and issue final subcontractor clearances and obtain warranties. So unresolved subcontractor issues delay finalisation and create downstream claims. A formal notice of practical completion. This is an important and significant one. It's important to issue the written notice to the superintendent and principal requesting certification. Confirm if any outstanding works prevent certification, and ensure the principal's response is documented for future reference. So practical completion must be formally requested and responded to. Silence or informal acceptance creates risk. So just coming back to references to the Australian Standard 2124, Clause 35.5 deals with the extensions of time. Clause 35.6, liquidated damages. And Clause 42.5 deals with the certificate of practical completion. These clauses govern the certification mechanics, and it's really important to follow them precisely. Okay, just moving on to a case study, H&M versus Golden Rain. In this case, Golden Rain engaged H&M Constructions for apartment construction. The issue was whether conditional practical completion certificate was valid under the contract and its impact on liquidated damages. And Stevens and Jay of the Supreme Court held that conditional certificate is invalid as the contract required either unqualified certificate or explicit refusal reasons. As the invalid certificate meant practical completion had not been achieved, it allowed the principal to claim liquidated damages. So, in summary, the conditional practical completion certificates are invalid, and they expose contractors to ongoing liquidated damages liability. But just moving on to final completion, contract closeout. The final completion checklist overview, why it matters. It marks the end of the defect liability period. It ensures all outstanding works are rectified, triggers the final release of retention funds. It prevents unresolved claims and disputes, and ensures all financial and administrative closeout steps are completed. This is where financial, contractual, and legal loose ends are resolved. So the key financial completion objectives is to confirm all outstanding defects have been rectified, ensure all contractually required documentation is submitted, finalise all outstanding payments and financial obligations, and formally close out the contract, both with the principal and the subcontractors. The key final completion review areas, there's 8 of them, and what this checklist is about is preventing post-completion disputes. So 1, retention release and security finalisation. It's important to verify contractual conditions for final release of retention, confirm all variations and claims are resolved before retention is paid, and ensure all bank guarantees or other security instruments are discharged. It's significant and important that all variations and claims be resolved before the release. 2. Final defects rectification and certification. It's important to conduct a final defects liability inspection and obtain sign-off, confirm rectification of all previously identified defects, ensure any latent defects obligations are properly documented, and obtain contractor certification for defect rectifications. So, latent defect obligations must be clearly recorded. Warranties and post-completion obligations. Ensure that all subcontractors and suppliers provide the required warranties. Confirm all manufacturer warranties are handed over to the principal, and identify ongoing maintenance obligations and handover documentation. Warranty management often outlives the project itself, and that's why closing these matters out and first identifying them and addressing them is so important. And number 4, payment of the final contract sum. Ensure the final payment claim is submitted and certified. Confirm that there are no outstanding payment disputes, and verify that all agreed variations and cost adjustments are settled. A clean reconciliation and final account avoids future claims and uncertainty surrounding entitlement. So just coming back to references to AS 2124. So Clause 37 defines defects liability period obligations, and Clause 42.9 sets the condition for final release of retention. These clauses formalise the end of the relationship effectively. So what does that look like? The closeout steps ensure that all required notices and final contract reports are submitted, confirm any outstanding dispute resolution processes are resolved, and obtain principal's formal confirmation of contract closeout. The formalisation of the closure of the contract prevents disputes that are often resurrected later. Number 6, project documentation and record archiving. Construction disputes often arise years later, so these records are critical. And so by finalising as-built drawings, manuals, reports, site diaries, daily reports, archiving, the storing of finalised financial records, payment records and claims are properly archived is an important step, because they may prove to be critical if a dispute arises in the future. So final claims and releases protect the head contractor. So you should confirm all subcontractors have completed their obligations, ensure all subcontractors have met their final claims, obtain subcontractor final payment sign-offs, and issue final certificates for subcontractor work completion. So what are the risks and legal considerations for final closeout? The point here is that final releases and waivers must be properly documented. It's important to identify any outstanding or potential legal risks from unresolved claims. It's also important to ensure release and waiver clauses in the final agreement are properly documented, and that indemnities and liability releases are in place before signing off. So looking at AS 2124 again, Clause 37 specifies final defect rectification requirements. Clause 42 governs final security and retention releases, and Clause 46 final contract closeout and dispute resolution steps. This is a final risk management stage under the contract. Just moving on to a case study now relating to final completion and documentation issues. The case is Ian Delbridge Proprietary Limited versus Warrandyte High School. Victorian reports. This case involves a conditional final certificate as undermining certainty and finality. It involved a contract provided for the issuance of a final certificate, binding unless disputed within 14 days. The architect issued a certificate claiming a sum payable by the builder, accompanied by documents suggesting further adjustments pending the submission of additional information. The certificate was challenged as not constituting a valid final certificate. In that case, the judge said it seemed clear that the document issued, although on the face purported to be a final certificate, it's not intended by the architect to have the effect of a final certificate under the contract. The far-reaching effects of the contractual final certificate is to be seen in the decision of House of Lords in P&MK Proprietary Limited. So just remember, conditional final certificates undermine this certainty, and it's important to close it out properly. So, what are some contract administration tips and traps? Agreeing on payment claim format. Clearly define and agree on the format details and documentation required for payment claims at the outset of the project. Ensure that the agreed format explicitly aligns with the contractual provisions. Agreeing the format early avoids technical disputes later, and that's why it matters. It reduces the potential for disputes over validity or delays in payments, enhances clarity, and ensures efficient claiming process. The ticks and traps. A trap, missing time bars for claims. Contractors frequently miss crucial contractual deadlines for submitting claims or notices, losing their entitlement. And missing notice deadlines is one of the most common and fatal errors. And the way to avoid that is to maintain a clear schedule identifying all contractual notice deadlines, and to regularly review claims during the monthly checklists. So tip, why site reports matter. So these reports provide early warning and provide strong evidence. So implementing them as a mandatory reporting for all site managers and supervisors ensures accurate tracking of progress and resources, the identification of delays and variations or disputes early, and enhances accountability at the site level. So here's an example of a report template, and it shows what a meaningful report should look like. The date, the project, the site supervisor, the overall project progress, tasks completed in that week, variations identified, any incidents, and includes some site photos. So what are the key takeaways? Good contract administration reduces disputes, preserves entitlement, and limits litigation risk. And so with that, it's really important that you observe all the contractual provisions that pertain to variations, extensions of time, disputes, and scope. That concludes the presentation. Thank you all for your time and thanks for attending. I hope that you found it insightful. And any questions you have, please let us know.